Hi guys. Sorry we got a little late in recording these answers. Once the rhythm breaks, sometimes it's difficult to catch back on. As you know, normally in our community conference calls, every Thursday, every other Thursday, we do it live. But this last Thursday, I couldn't do it live, so I'm trying to record these. And of course, we have another community conference call coming up next Thursday, which is the 28th. So we can talk again there. Let's start with the first question that I see, profile 1235, non-capped to capped H-1B transfer. So here the idea is, I've got my H-1B approved through an employer who was subject to the quota. I don't want to join them. I want to join a non-profit or a quota exempt. Remember, not all non-profits are quota exempt. So let's say you want to join now a quota exempt. So the question is, I've got a quota approval. I'm going to a non-quota employer. Can I come back to quota sometime in the future because my earlier quota was approved? And the answer is probably yes. I'm not 100% sure because I do not believe there is anything given in writing by USCIS to cover something like this. But from what I remember, and I haven't looked at the statute or the regulations either, from what I do remember, it should not be a problem because the language of the law reads something like anyone who's had an H1 approval within the last 6 years, they would be exempt from the quota. So it looks like we should be okay. So if you go from, once you've got your quota approval, then you go to a non-quota, and sometime in the future you want to come back to quota, you should not have a quota issue because you already have an approval, I think. Don't take my word for it. This is just my opinion, and I don't like to give opinions unless I don't like to give something a certainty label unless I'm really certain. So I believe that to be the case, but I'm not really certain. So next question is, within how many years can I move over? I believe it'll be 6 from October 1st, I believe. Do you see any risks in such transfers? I would have to look at the law. Somebody should spend some time researching this issue to make sure we've covered everything. I personally think it should be okay. And I do recall that our office had checked about this issue a few months ago. And I think the answer was what I just gave you. Okay. What if the H-1B is withdrawn? So the question here is, I have not gone for H-1 stamping, and the quota employer revokes my H-1. Is that going to be a problem? I don't think so. I don't believe this to be an issue. It's the approval that's key. I don't think subsequent revocation takes away your quota exempt issue, because it appears to me that once the H1 is approved, whether or not it's stamped, even if it is revoked, it should not cause you any problems. The last question is about wife's pregnancy. If my wife is pregnant, does that cause a problem in my H1B stamping or in her H4 stamping? And the answer is it should not. I don't see any issues with pregnancy. So there is a UNVA student who was picked in lottery. I guess they must have gone through the master's quota. But then the UNVA lost its accreditation. And because of that, the H-1B was denied. So their questions are, how to check if the SEVIP is still active? You should contact SEVIP, SEVIP, directly. Of course, you should also call your International Students Office. Can I work legally until my OPT extension expires? You see, there are two points of view, the conservative one and the more aggressive one. The conservative people would say, well, if the accreditation is taken away, has the school lost the right to issue I-20s? Is the OPT gone? Maybe you should stop working. The more aggressive school would say, you've given me, Mr. USCIS, you've given me this employment authorization. Now, unless you revoke it, and you let me know specifically that you're revoking it, why should I not continue using it? And so it's your choice. You want to be aggressive, keep using it. I don't know what the downside can be. Maximum is being out of status. You go outside for visa stamping again. For something like H1, it would not matter. For student visa already, because you are a part of UNVA, you have enough issues. If consulate wants to make an issue, they can. But for H1, they cannot. If service is cancelled, can I transfer or join? That depends. If USCIS is willing to work with, actually it's ICE in this case, is willing to work with the new school, and they have taken into consideration the special factors associated with UNVA loss of accreditation. So there's no clear answer. Talk with the transferring school or the transfer to school. Ask them if they can contact CEVIP and find out what's going on. How come USCIS approved my OPT and OPT extension but not H1B? They did not notice. They may not have become aware. And also, by the way, I'm quite sure about this, that a school does not have to be accredited to be able to issue I-20s. Or there's a different level of accreditation. I could be wrong about this. I haven't looked into this either, but I suspect the standards are different for H1 master's quota and for I-20 and OPT. The standards are different. Disha Ram, current status is H4, valid till 20th October 2014. I-9 is expiring earlier in September 2013 because of passport. Now got a new passport, applied for H1. Approval notice of the H1 is till 1st October, or from 1st October 2013 till 20th September. So there is just a 2-day period, 29th and 30th September, where you are out of status. This is a very common situation, and again there is no clear-cut answer. What is the situation? You applied for H1 under quota. It got approved with the I-94, so the change of status was approved, everything was approved. But there is a gap between when your previous status ends and October 1st comes. What do you do in these situations? Well, if you want to be ultra conservative, you go outside, get your H1 visa stamping, and return, and you're not allowed to return earlier than 10 days before October 1st. So, ultra conservative thing to do is go outside, get H1 visa stamping, and come back. I personally feel these are de minimis violations. I don't think there are going to be any problem. So if you continue to stay for 2 extra days, I don't think it's going to be an issue. Good idea to call USCIS customer service, ask them the same question, make a note of the date and time you talked with them and what they told you. If they say it's okay, make a note of that. That gives you additional protection. What is the worst case scenario? I can't think of anything. I mean, they could say you were out of status, but it's such a hyper technical issue that I doubt very much it's going to come up. So 2 days or a week or so in between when the H1 kicks in, if you've received the I-94 and when between the time the old status expires, I think you should be okay. That's my best guess. Can you approach the local field office for I-94 for 2 days? I would call USCIS customer service. I can travel to Canada, Mexico to get new I-94. Sure, you can try doing that as well. The good thing is if you go to Canada, Mexico because of AVR, automatic visa revalidation, you may not need a visa stamping. Okay, so yeah, that appears to be an option. But start with calling USCIS. Okay. Personally, I don't think it's a problem if you start working on October 1st. Yoda Stefa, asylum. Oh, I have no idea about asylum issues. So you lost your passport before biometric fingerprints were taken. You've informed the police department. You have a case number. Would it be a problem during the interview? I do not know the answer to that question. Normally, I have personally done AOS cases, adjustment of status cases, where the passport was lost. Where the passport was expired and it couldn't be renewed. This particular case was a guy from the Greek army or from Greece. If he wanted to renew his passport, he would have to go back to Greece and serve for 2 years in the Greek army. And he did not want to do that. So we were able to get his adjustment of status through an employment-based case without him having a passport. That's just my 2 cents. I cannot be specific about your case because I don't know enough about asylum laws. Let me pause this for a second. I'll get back with this. This is a little bit of a long answer. Okay, so getting back to this question, what has happened is PERM has been denied after audit. H-1B is maxing pretty soon. What do I do? First of all, you file an appeal against the PERM denial. Okay. Appeal usually stays pending for about 3+ years. While the appeal is pending, you can keep getting H-1B extensions. Okay. Then you get an extension and time it in such a way that you can withdraw the appeal and file a second PERM application. So you'll do all the recruitment, everything, have everything ready, and apply for an H1 extension based upon the appeal. Apply for the extension 6 months ahead of time. So if your H1 is expiring on October 1st, you apply on April 1st, make sure you got your extension. Then withdraw the appeal and file the second PERM case. That is usually the way I would handle this sort of situation. Should you find another employer? You can if you want. If the old employer does not withdraw your appeal, Abhishek, you can find another employer, and the benefit of H1 extension can be taken by that employer even though the appeal is pending through the other employer. Okay. EB3 to EB2 porting from Raj. Valid I-140 from company A under EB3. EB2 has been started. So the question is, when do we need to port? Well, first of all, this porting has become an automatic process. If you have an earlier approved I-140, USCIS does sweeps of their approval databases, and they automatically give you the earliest priority date to which you are eligible. So really it has become more or less irrelevant now to worry about porting. What you can do is, this is what we do. When we file the second I-140, and again, it's not something we have to do, but it can be done this way. When we file the second I-140, we attach a copy of the old I-140, request that please port the priority date, and issue an EB2 I-140 showing the EB3 priority date. If not that, when the priority date of the EB3 PD with an EB2 classification becomes current, you can also file the two I-140 copies together with the new I-485. So there are several ways of doing it. It's usually not that big an issue. Don't worry about it. Do we need to reveal any information at the time of submission of my labor? No. When the second employer files, they don't have to reveal anything about another filing by another employer. Okay. Can an H4 holder participate in a lottery, like where you make money? And in my view, yes. I don't see any law that says you cannot do that. Again, I don't have anything concrete to point out to, but I cannot think of any law that would disallow such a participation. It's a game of chance. You're not really working. A few weeks ago actually, there was a very interesting conversation in one of the immigration lawyers' listserv. A lawyer had written something about, I believe that H4 people can work if the work is being performed outside USA, even though they are inside USA. And there were a lot of opinions, and I was a little mistaken actually. I I misremembered a law. But when I look back into this issue, I disagree. I still disagree. I think if work is performed on U.S. soil, it's very risky to imagine that USCIS will not consider that unauthorized employment. But lottery is not employment under any rules that I can think of. H1 approved, but change of status from H4 to H1 denied. So the question is, what do we do in a situation like that? Okay, because you had traveled while the H4 to H1 was pending. So the question is, how do I get back onto H1? You can go for visa stamping, or you can reapply for the H1 change of status. This is like filing a new application all over again. They can deny the application, revoke the H1, they can do all sorts of things. But if the H1 is clean, change of status is very much possible. Stamping, as you know, going to India for stamping, I don't know how I feel about that. This morning in the radio show, there's a case from Singapore. A guy's H1 was denied, no explanation given. Papers sent to USCIS for revocation. It's a mess. Okay. I would certainly do a change of status if I were you, Rati. Okay. How much would it cost? Check with your lawyers. I'm not sure what the filing fees, etc. are. But as far as the H1 filing is concerned, the change of status is, remember, change of status to H1, new H1, transfer of H1, extension of H1, amendment of H1. These are all the same paperwork with the same problems that can mean denial. Okay. If you go to India, it doesn't get approved, can I come back on H4? Yes, you can. After coming back, can I apply my H1 again? Yes, you can. Okay. One thing though, what if USCIS revokes the H1 at the request of the consulate? Are you still exempt from the quota? I think you are. Okay. Again, I can't promise you that this is the absolute 100% correct answer, but offhand, I believe this to be true. Okay. Next question. Oh, this is a continuation of Bob K. basically quoted the previous question. Once I join BBB in future, can I change? Huh. I think I covered that issue already, Bob. I wonder if that was your question about the quota and non-quota. That was the first question I dealt with this morning. Whatever I know, I have shared with you. Yeah, it's not your question, but I have already dealt with this issue. So if it's not clear, join me in the next Thursday's call, which is, what is it, 29th? Yeah, a week from now. Okay. Let's go on to the next question. V. Gupta. I do not have birth certificate. I found out that I need non-availability of birth certificate in 2 affidavits. But the local municipal corporation is not issuing non-availability. You should get something from them, even if it is a letter saying that we don't issue non-availability. Otherwise, USCIS is going to give you a hard time. I think you should get a lawyer actually. Because if nothing else, you should be able to document through an affidavit that you tried your very best. By the way, the affidavits can be notarized anywhere. It's not a problem. And your birth certificate can be evidenced by affidavits from your mom and dad. But this is a little complicated. You should get yourself a lawyer. It's not so much that the proof is complicated. It's just that dealing with USCIS, God knows what they're going to come up with. It can get tricky. Okay. Next question from the same individual is, so I'm supervising 100 people, and managing several accounts of millions of dollars, but my title is Program Analyst Principal Leader. Does this create a problem for my EB1, I believe EB1C application? And the answer is no. It's the job description which is more important. So don't worry too much about that. You should be okay. Next question is from Joyce Sir 1, who says, I'm on H1B working in City X. I'm planning to move to City Y and work from home. Is work from home allowed on H1B? Yes. Do I have to get my H1B amended? Yes. Will there be any issue when I go for visa stamping? There are issues. It's already so many issues in visa stamping. Working from home, in my view, does not create any additional issues. State taxes, I don't know anything about which state taxes. That's something you need to clarify with an accountant. I'm not ashamed to admit I almost failed my tax exam. I really have no interest in taxes, so I was able to give it very little attention. And you don't want my advice on taxes. Can I change my job locations during PERM process? Well, that's something your lawyers have to decide. Normally, when we draft a PERM, we draft it in such a way that change in job location has absolutely no effect. So it all depends upon the drafting and the proper venue. Most of these transferable jobs should be filed from corporate headquarters. Okay? And if you do that, then if you keep changing jobs, it's not going to hurt you. I-140 priority date porting with new employer. Even if the old employer revokes I-140. Yeah, even if the old employer revokes your I-140, the priority date can still be transferred. It's no problem. Okay, USCIS has made that clear. There was a little bit of a flip and toss on that for a while, but their most recent pronouncement, about a year or 2 years old, is quite clear. So even if it is revoked, you can transfer the priority date unless the revocation is done by USCIS for fraud. Again, I'm going to have to pause for a second. So this question from Newbie, Newbie says, my husband's green card is going on and the PD is going to get current. I'm on H1 visa. Can I travel back on this H1 visa even if my 485 is, once my 485 is going to be added? Let me just double check. So if my 485 is pending, can I travel back on H1 visa? In my opinion, yes, you can. Because you have an H1 stamp. You see, the laws are a little unclear because we're really dealing with memoranda from USCIS, not with regulations. No, there is a regulation on this actually. I could be wrong. It's very clear if you were the primary applicant, and your 485 is pending, you can either use advanced parole or use H1 visa. They are both equally effective. And if you used H1 advanced parole to come back, you would still be considered to be on H1. Okay. However, it's not clear what happens if you are a derivative. Okay, if it's your husband's application. I think it's still the same law. I think traveling on H1 visa should not hurt your 485. Can you use an advanced parole that was approved while you were outside USA? Probably not. Okay. So what is the average time to receive fingerprinting notice? I have no answer to that. Too many things, too many variables. Just as a general rule, USCIS's avowed aim or their declared aim is to do everything within 6 months. That's their goal. So in general, the default answer for everything is about 6 months. Deepti Shah, 12, studied on H4 for 2 semesters in an accredited university, took 1 course in each semester, not getting F1 approval. Now she's got her F1 approved, applied for H1, don't want to enroll. You have the same issue. You have the same issue that you're going to have a gap between your F1 and your H1, right? F1 approval date is August 3rd. I-20 starts from September 3rd. If I-20 date is considered a start date, deferring F1 to spring semester will help to maintain. This is something you should discuss with your International Students Office. I'm not sure that deferral keeps you in F1 status. And I don't believe there is any grace period in a situation like this. So talk with your International Students Office if there is anything they can do to maintain your student status. I don't see any option except that you should be going to school full time. DG Thomas wants to know, wife is becoming a citizen. I'm planning to apply for green card through her. H1 is pending. Well, first of all, spouses of US citizens don't have to demonstrate legal status. They only have to demonstrate that they entered US legally. So don't worry about it. Okay? You're going to be fine with it. Whatever you have. As long as your entry was legal, even if you're in between H1 extensions, there is no problem. Victor 25. What are the criteria for 7th year H1B extension? Okay, H1B extension is given in one of the two ways. Either your labor cert perm has been pending 1 year on the date from which you want to begin the H1 extension, or your I-140 is approved, regardless of when your perm was filed. Now you can apply for you're right, you can apply for your H1 6 months ahead of time, right? So again, taking April, October example. So let's say you filed your perm in October of 2013, next month or 2 months from now, okay? You will become eligible for H1 extension based upon the 1 year rule on October 2nd, 2014, right? 1 year pending. You can apply for your H1 extension 6 months ahead of time, April 2nd, 2014. But it will kick in only on October 2nd, 2014. So you can apply 6 months ahead of time as long as the date on which the H1 begins, on that date, perm would have been pending for 1 year or more. I trust that makes it clear. Does it matter what status you are in when you apply for 7th year extension? It does not matter. It used to be a problem a few years ago before William Yates, who was, I believe he was the Director of Operations for USCIS, Service Centers, or maybe entire USCIS. When he retired, he made it clear that you do not have to be on H4 to get H1 extension beyond 6 years. You do not have to be on H1. So even if you are on H4, when you become eligible, you can apply for 7th year extension of H1. Previously, USCIS used to think that extension means you've got to be on H1. So even if there's a one day gap between your H1 and your H1 extension, you can't have it. That's not the law anymore. Even if you're on H4, you can get your extension. Let me make sure I got all your questions. I think I got it. Do we need to wait for 365-day completion before we apply for 7th year extension? No. Like I told you. So let's say your current H1 is expiring 6 months from now. You can actually apply for the next year's extension now. So you can always apply 6 months ahead of time. Caliber 91. EAD extension based upon pending BIA appeal. This case, what happened was I-130 was denied, 485 was denied, appeal is pending with Board of Immigration Appeals, H1B is not valid. Can I file for EAD extension based upon pending appeal? As far as I know, No. What is the possible outcome of the I-130 appeal? I do not know. I don't know what the grounds of denial were. So double check my answer on the EAD issue. I'm quite certain that just because the appeal is pending, you do not have a right to extend your EAD. Okay, H-1B transfer to two companies. Pramod says, I'm working in company A on H-1B. Company B transferred my H-1B visa. I haven't joined them. Now I have a very good offer from company C. Company C is asking for documents to initiate the process. Which document should I give, A's or B's? If you're still working for A, Pramod ji, you should give A's documents. Okay, but I think there is a question on Form I-129 which says what was the last approved H-1. So you probably will have to give that information to the company lawyers, but the most of the information that you have to give is the one that relates to company A where you're currently working. Dummy 987, 1-year project in a different state. Client initially, so he's on H-1B, I guess. I got an 1-year project in a different state. Client initially said it was for 1 year, then they gave a PO till December. I'm here for last 3 months. No amendment was filed. Am I okay? A lot of information missing here. So I'm assuming that you were approved for one state and you moved to another. So an amendment should have been filed. Am I okay? No. Should I file an amendment ASAP? Absolutely. Do I need letters from middle and end client, middle vendor and end client? Yes. Can I provide format for each? No. No, I cannot provide the format for letters. I have an article written on this issue. You can check it out. Sorry guys, I have to take this call. I'll return to the recordings. Sorry guys, interruptions, a lot of interruptions. I'm doing this on a day that's not a regular day for me. So I was talking about a sample letter. So if you go to our website, immigration.com, and look at the top panel and go to About Us, and there is in the list there's a particular place for articles written by me. You see this article, not this one, Proving Existence of a Job for H-1B. Some of my published articles are on our website, not all of them. But if you go into this article, I remember very clearly that I had put in a sample letter in here. Yeah, there is a sample letter in here. So here is a letter. Now this is by no means is it complete, this letter, but that can form a good basis for your lawyers to draft something specific for you. Okay, so once again, it's on our website. You can take a look at that article. Let me get back to the other questions. Yeah, this is the page. This is about us, about Rajiv S. Khanna, and then here is the Rajiv's articles entry. So when you click on that, you come to that page that I was showing you. Okay. All right. Let's get back to the questions from A.R. Jung, or Arjun actually, Arjun G. Okay. I have my mind on in Germany. Okay. So Rajiv G, from August bulletin Jan 2008 is current date. So my priority date will become current soon. Once the 45 is filed and while waiting to get green card, can I change job location? Very tricky question to answer. After 180 days, sure. Before that, I would be a little uncomfortable unless I reviewed your PERM application. When do you think my priority date of June 2008 will be current? No idea. How many months will it stay current? No idea, Arjun. Sorry. Green card for parents. Same problem. The marriage issue. So, one thing I want you to be careful with is applying for permanent residence when parents are visiting, because USCIS can take the opinion that the entry on tourist visa was fraudulent if you had a preconceived intention of applying for a green card. Of course, once they are in the United States, if they change their mind, that's different. But if they entered with the intention to change to green card, it could be said that their entry on tourist visa was fraudulent. I'm actually dealing with these sorts of issues right now. At least in the case of a U.S. citizen, their spouse entered on a tourist visa, and they are a European couple, and they applied for change of status very soon after she entered, like within 3 days or so. USCIS has denied the case. She's stuck with a fraud finding. We are fighting that out. I think it's a very unfair finding, but be careful with that part. So how do we prove? I think you should get a lawyer. When you have these birth certificate issues, it's better not to deal with it yourself. Okay? You could. I mean, if you have enough evidence, you seem to have a lot of information here. Copy of memorandum of marriage from registrar, birth certificates. For birth certificates, you have non-availability, which is good. Document does not have a date. Well, I don't know. Affidavit from grandfather, that should be okay. Birth certificate related documents of my mother are affidavit from grandmother. That's good. High school certificate. How about non-availability? You need that. Also, oh, by the way, there's further down, there's another question. I remember reading it yesterday. That people who are giving affidavit of birth, do they have to be adults when the person is born? No. USCIS's language used to be they should be alive when the person is born. So even if they are young, when the person is born, they can provide an affidavit. Okay. I do want you to get a lawyer, sir. I don't think this issue is something you should be handling yourself. Okay. I'm concerned also with that tourist visa issue. Somebody should look at your paperwork. So get yourself somebody locally, and have them file the paperwork for you. Babu Ani, L1A and H1A. H1. I'm on L1A. Company B applied for H1 change of status. H1 is still under review, but the employer is now filing for EB1, so he doesn't want to change status. So what you want is you want to get the H1, but you don't want to change status. You can withdraw the change of status request. You can. It's going to be a little complicated, and the employer who's filed the H1 has to move fast, but you certainly can. But if the change of status is approved, then you have to convert back to L1A. Either you have to refile and ask for a change of status to L1A, or you have to go outside USA, re-enter USA using L1 visa. Okay, so if the EB1 is denied, can you go back to H1 with a visa stamp? Yes, you can go to H1. Houston Krishna, aha, same problem, right? Parents' green card, these have become unnecessary issues. US citizen applied for parents' green card processing 1 year back with self-affidavit and 10th class mark sheet as supporting evidence. Father was born in 1942, mother in 1948, very few older relatives. Question number 1. Do we need to submit affidavit from older relatives who are adults? I just answered that question. How many affidavits? 2. Do they need originals? You should have them in your possession, but you can send copies. If you feel we need to submit affidavit from adults when the applicant was born, is it okay to get them from non-relatives? Affidavits can come from non-relatives. It's not a problem. But you need to have either a certificate of non-availability. Sometimes we have people who were born in Pakistan side of India. It used to be undivided, now it is Pakistan side of India. In those cases, certificate of non-availability is usually not needed. Okay. So, but you will need certificate of non-availability of birth certificates. Okay, these are the questions that were added on by Monica later on, and I think I'm coming to the end. I also have to start a bunch of other things. So I will be able to finish it, I think, today. I don't want to postpone this anymore. You guys have been waiting long enough. Working with employer A till September 2010. Move to employer B. Okay, so can my employer A file for the 485 even if I'm not working with them? Yes. As long as you have the intention to join them and they have the intention to rehire you, you can file the 485. And interestingly, once this 485 has been pending 180 days, you no longer have to join them. You can do AC-21 over to any employer, including the current employer you're working for. Do I need to have a valid H-1B with employer A to proceed with 485? No. Is it RFE prone? Not any more than usual. What is the best time to move back to employer A? It's up to you. Like I said, after 180 days, you don't even have to move back. As long as on the date you file the 485, you have the good faith intention to join them. If my employer B starts my green card and ports the priority date, will employer A still have the authority to file 485? Yes. Just because the priority date of the old employer has been ported by the new employer does not take away your right to file 485 through the old employer. No problem. Next question, valid I-140 from company A under EB3. Company B started green card under EB2. Labor approved. When do we port? I already answered this question earlier on. There is no big problem with the porting. Don't worry about it. Even if they don't do anything, you will automatically get your date. L1A status, I have already answered this question. Oh no, maybe this is a little bit different question. So it sounds like a very much similar question. Working for company A on L1A, asked one of the consultants to file H1B. They filed it with change of status and I-94. It's under initial review. I don't want to join them. I want to stay on L1A. Ask consultant to withdraw my H1B. They are not willing to do so. Okay. It's a very odd situation where you are the one affected by the H1 change of status, and if you call USCIS, they won't let you do anything, which is kind of silly. Okay. Your status will be changed to H1B if you don't withdraw it. Try calling USCIS customer service, see if you can do anything about the withdrawal of status. Yeah, if you don't join on October 1st and you are converted to H1B, you'll be out of status. So you have to do something about it. Of course, you can, after October 1st, or just a day before October 1st, leave US, re-enter USA on October 1st using your L1A, you are back on L1. Or you can apply for a change of status back to L1 after the H1B is approved, which is more cumbersome. Okay? But if you don't join them and the change of status has been approved, you'll be out of status. I think it's the same question. Yeah, same question twice. Okay. Next question, this is the last question. 6 years of H1 will be completed in a month. We got 1 year of extension on my approved labor. So expiry date is October 14th. Qualifications are 3 years bachelor's in computer science, 2 years master's in computer science, 9 years of experience in computer science area. Job requires master's plus 1 year. My lawyer evaluated my education. First of all, you cannot use education equivalence of experience for green card purposes. You can use it for, oh, this is not the last, we have more questions. Okay, well, I'll do the best I can. I haven't read the page 2, so I don't know how many more questions are. So you cannot use experience equivalence for master's degree. Evaluations don't work for that purpose. So questions are, can I transfer my H1B to another company and start new labor? Sure. Can I file new I-140 with expired labor certification from the current company? No. What is the best option for applying new I-140 from current employer? MTR, AAO, or appeal? That's impossible. Is my education master's plus 1 year? It is not. It is not. Evaluation, I mean, I'm sorry to say, but this is a very, very basic issue of law. Every lawyer should know this. You cannot use experience as equivalent to education for green card. You can say something like that, this MS plus 1 or master's plus 3 or bachelor's plus 5, that's okay. But you cannot just say master's plus 3 or master's plus 1 and then try to use experience to gain master's equivalence. It cannot be done. That case is not winnable. Okay, well, oh, two more questions. I haven't read these, sorry, so I'll have to read them now. Oh yeah, this has already been handled. So I took care of this question. This is about that 2 days gap in the H1 and H4 status. I already handled that. Okay, entered USA on L1B from company A, which would have expired in July 2013. They filed L1B to L1A conversion. It's approved. Somebody filed H1B, change of status. Will my H1B be approved since my status changed from L1B to L1A? Yes. Yes, it should be. I don't think it should be a problem. Double check with USCIS customer service. I don't think it should be a problem. Will it change my status again from L1A to H1B after 1st October? Yes. How can I continue on L1A? I have answered this question 2 or 3 times. Just review the rest of the recording. Okay, last question. Yeah, this is the last question. I work for an organization as a full-time, so I have a non-cap exempt H1B. So you have a quota H1B, non-cap exempt. There are 2 negatives. I guess what you're saying, you have a quota H1. Now I have an offer from a non-profit which comes under, so I'll be converted to cap exempt. If I start working on cap exempt, I already answered this question also. I think this is a repeat. So if you just listen to the recording all the way through, all these questions have been already answered. Guys, sorry about this very choppy recording, but I'm pretty sure that in future we won't have this issue. I like to keep the same every other Thursday, a live conversation, because it just wraps up everything right there. Okay, good talking with all of you. I'll see you in a week.